How are damages assessed in intellectual property law? Like most damages, the purpose is to compensate the plaintiff for the loss suffered because of the infringement. The damages are calculated as the depreciation caused by the infringement to the property's value. For intellectual property law, there are four key areas. The first is copyright, which is the exclusive rights over the expression of an idea. The next is trademark. It's a sign used to distinguish goods and services when registered. Next up, we have designs. That's the protection of visual elements of intellectual property, which also requires registration. And finally, patents. This protects inventions after registration. Now, generally, the way damages are assessed are pretty similar due to that principle mentioned earlier, and the court will take two approaches when actually calculating these damages. These are the loss of sales approach and the license fee approach. Now, the loss of sales approach can be very hard to prove, as the respondent's sale needs to be proven as a lost sale for the applicant. In the case of Elwood, there was a claim for damages where the intellectual property rights over a t-shirt design was used by a competitor. The case suffered from the tough evidentiary burden outlined, and Justice Gordon allowed for the framework in assessing these kinds of damages. Step 1. Assume the respondent sought the applicant's market share. Step 2. Assume the respondent's sales were actually lost sales for the applicant. Now, step 3. Discount step 2 in a way that shows that not all sales to the respondent would have really been sales for the applicant. And step 4. Discount individual unit sales where possible on the facts of the case. So the applicant really needs to quantify the fact that their sales were lost to the respondent. The next approach is a license fee approach. Now, this approach has the court award damages to the applicant in a way that would cover a fair license fee had the respondent paid for such a license over the property. The key issue here is that if the applicant and respondents are competitors, it's unlikely that the applicant would have actually allowed for such a license. Therefore, this damage is most appropriate where the respondent would have likely paid the fee over not using the work, and the applicant would have allowed for this fee. There are specific sections that impact and reduce damages for each of the four areas of intellectual property law mentioned above. For copyright specifically, damages are mostly covered under Section 115 of the Copyright Act. Now, under subsection 4 of 115, there may be additional damages for reasons such as flagrancy, deterrence, the conduct of the respondent post-infringement, whether the infringement involved the conversion of a hard copy to an analog or digital, such as illegally burning CDs, and any other benefit the defendant receives from the infringement. Now, under Section 115, subsection 3 of the Copyright Act, where a respondent establishes a lack of awareness of the copyright, the applicant may not be awarded damages. They may receive an account of profits, however, that's a completely different topic for another video. Now, designs and patents have almost identical defences to the one mentioned earlier, the innocent infringement, based on their legislation. However, there is no legislative protection for trademarks. Well, there is, but it's not the same. Under a Section 122 of the Trademark Act, where a trademark is used in good faith, or the respondent lodged a disclaimer, damages may not be awarded. However, the court can still award an injunction. As per Section 126 of the Trademarks Act, if the trademark has not been used and should be removed, damages may not be awarded. So that means it just hasn't been used in ages and, shouldn't really be there. In conclusion, damages are calculated on a case-by-case basis in intellectual property as well as all other areas of the law. The damages can be calculated from a license fee or a loss of sales approach. And there are legislative protections for innocent infringements, except for trademarks. That's based on good faith. Thanks for watching.